Good day everyone. I am Dr. Simranjeet Kaur, Professor at the School of Law, City University, Ludhiana, Punjab. It's my pleasure to welcome you all to this insightful lecture on the classification of laws and overview. Law is a fundamental part of any structural society, and understanding its classification is crucial for both legal professionals and students of law. In today's session, we will explore how laws are systematically categorized and why such classification is essential in legal studies and practice. By the end of this lecture, the learners will gain a fundamental understanding of the classification of laws and their historical development, insights into the significance and the purpose of the legal classification in structuring the legal system. Learners will learn an overview of the different categories of the law, including public and private law, civil and criminal law, national and international law, substantive and procedural law, among others. Knowledge about how these classifications impact the study and application of the law in various legal frameworks. After attending these lectures, learners will be able to define and explain the classification of laws, differentiate between the various legal classifications, and understand their practical implication. Analyze how different branches of law interact and overlap. Apply the knowledge of legal classifications to the real legal scenario and the cases. So, let's start with the topic. Introductory part. The classification of law is an ancient idea that goes back in time. The original organizers of the things were the Roman legal experts. Similarly, the ancient Hindu legals created 18 categories or the section for Vihara, which is about civil law matters. Criminal law is separated from the civil law and put into the different groups. However, there are two limits to how laws are categorized. Any arrangement is only useful in relation to the other things, and there cannot be a set of a big principle or rules for it. The old guidelines changed over the time in how they worked and the situations they were used. New guidelines based on the new ideas also came up. So, a new way of organizing is needed. The Roman legal experts used to organize laws, but today's world thinks that their way of organizing isn't clear. Law cannot be classified in many ways, such as criminal law and civil law, public law and private law. The real rules and the processes rules, laws of one country and the law that works across the country, and so on. So let's discuss first the meaning of the classification of the law. The classification of law refers to the systematic arrangement and categorizations of the various legal principles, rules, and the areas of the law based on their nature, purpose, and scope. It involves grouping different type of laws together to facilitate better understanding, organization, and study of the legal system. By classifying the laws, legal experts and practitioners can easily identify and differentiate between the different aspects of the law, making it more manageable to navigate the complex and diverse field of the legal regulations. The classifications help in structuring legal education, practice, and research, and it assists in clarifying the relationship between the different branches of law and their application in various situations. Overall, the classification of law contributes to the clearer and the more organized understanding of the legal framework. Now, let's discuss the purpose of the classifications of the law. The purpose of classifying the law is to bring order and clarity to intricate web of legal principles and regulations. By systematically categorizing different type of laws based upon their characteristics, nature, and scope, the classification process enhances the understanding, interpretation, and application of the legal framework. This organization aids the legal professionals, scholars, and the students in comprehending the diverse aspect of law more effectively. Furthermore, classification enables the streamlined legal education and research by providing a structured roadmap to navigate the complexity of the legal system. It assists in identifying the connections and distinctions between the various branches of the law, fostering a more cohesive understanding of the legal landscape. The classification of law also aids in legal practice by facilitating access to the relevant legal precedents and the principles. Ultimately, this systematic arrangement fosters a more efficient and accessible legal system, promoting informed decision making, whether in courtrooms, legislative bodies, or academic studies. So, now let's discuss what is classification of laws. The classification of law involved categorizing different type of laws based upon their nature, scope, and purpose. This helped in organizing and understanding the various branches of the law. Here are some common classifications of the law. Public law versus private law. This classification divides the law into the public law that deal with government and society, like constitutional law and administrative law, and private laws that regulate relationship between the individual and entities, like contract law and torts law. Substantive law versus procedural law. Substantive law defines the rights, duties, and responsibilities, while procedural law outline the process of enforcing those rights and resolving the disputes. Civil law versus criminal law. Civil law deals with the disputes between the individuals or entities seeking compensation or specific action, while criminal law addresses the offenses against the society, aiming to punish the wrongdoers. National law versus international law. National law pertains to rules within a specific country, while international law governs the relations between the countries and entities on the global scale. So, let's discuss the classification of law as international and national law. So, national law and international law is a classification that deals with the rules for how countries interact with each other. It's like a set of guidelines that countries follow when they have the dealings with one another. These rules are based on traditions and agreements that countries agree to follow when they interact. To put it in another way, international law is a collection of traditional and agreed upon rules that are considered official by well behaved countries when they deal with each other. According to the Oxford Dictionary, international law is defined as a set of rules that are created by the tradition or agreement between the countries and are seen as binding when countries interact with each other. This type of law mostly comes from the agreement treaties between well behaved countries. International law can be divided into two main parts. Public international law. This is the set of rules that controls how one country behave towards the other countries. For instance, if two countries agree to send back criminals who have run away to another country, that's an example of the public international law. Private international law, this means the rules that decide what happens when situations involve different countries. For example, if an Indian person and a British person make a deal in India, but it is supposed to be carried out in Nepal, the rules that decided what rights and duties the people have called private international law, municipal law, and the national law. Municipal law refers to the law of the specific nation, the laws that apply within the country's border. It is the internal law that governs the people who are the part of that country. This is different from the international law, which deals with how countries interact at a global level. Municipal law handles things like how individuals relate to each other within the country and how the country's government interact with its citizens. The government approves these laws. It is usually limited to the country's territory. Municipal laws can be classified into the two main parts: public law and the private law. Classification of law as a public and private law can be done as public and private law. The classification of law into the public and private law is a fundamental way of distinguishing between the different areas of the legal regulations. These two categories serve to organize the law based on the nature of the parties involved and the interest at stake. Public law. Public law refers to the part of the law that handles relationships between the legal entities like individuals and the government. It also deals with the interactions among the different parts of the country's institutions, including different branches of the government. Additionally, public law covers relationships that directly affect the society. It is about how the government functions and is accountable. This type of law sets the rule for how a country is organized and how it operates. It also defines how the government interact with its citizens. When we say public, we mean that the state itself or parts of it that have authority, as well as individuals or the bodies that have been given the power by the state. Public law is the branch of law that governs the relationship between the individuals or private entities and the state, as well as the structure and the operation of the government itself. It is the primarily concerned with the regulation of the public authorities, their powers, and their interaction with the individuals or the organizations. The main focus of the public law is to regulate the functioning of the government and to protect the public interest. Key characteristics of the public law: first is state involvement. Public law always involves the state, government, or public authorities as one of the parties. The state acts to enforce the laws and the regulations for the benefit of the society as a whole. Public interest. The purpose of the public law is to protect the public interest, maintain law and order, and regulate the behavior of the individual or organization when it affects the society at the large. Regulation of the government power. Public law ensures that government powers are exercised within the legal framework and there is accountability in the actions of the public officials and the bodies. Rights and the freedoms. Public law safeguards the fundamental rights and the freedoms of the individuals against the abuses by the state, ensuring fair treatment and equality before the law. Public law can be divided into the specific categories. Constitutional law. Constitutional law determines the nature of the state and how the government is structured. It's the highest form of the law, above all other laws. It outlines how the three branches of the government function. Regular laws get their importance from the constitutional law. Administrative law. Administrative law allows the creation of the public regulatory agencies. It covers laws, court decisions, and rules related to these agencies. These laws are made by the administrative agencies to define how they can use their powers and fulfill their duties through rules, regulations, orders, and the decisions. Now, let's discuss the criminal law. Criminal law defines what counts as a criminal offense, regulates how crimes are recognized, establishes charges and trials for the suspects, and set out the ways punishment and treatments are applied to the convicted offenders. Its main goal is to prevent the crime and penalize wrongdoers. Private law. Private law is the branch of the law that deals with the legal relationships and disputes between the individuals, organizations, or entities that are not of significant public concern. It governs the interaction and obligation of the private parties, such as individuals, businesses, and organizations, in their personal and business affairs. Private law encompasses a wide range of the legal matters, including contracts, property ownership, torts like negligence, civil wrongs, defamation, family laws such as marriage, divorce, and child custody, inheritance, and more. Its focus is on resolving conflicts and ensuring fairness in the private matters between individual and entities. In contrast to the public law, which governs relationship between the individuals and the government or the matters of the public interest, private law is primarily concerned with the rights, duties, and liabilities that individuals and entities have towards each other in their private interaction. Private law is the branch of law that governs the relationship between the private individuals, organizations, and entities. It deals with the issue where individual or organization seek to resolve their personal dispute or enforce their rights without involving the government, except for the enforcement purposes. Unlike public law, where the government is a party, private law focuses on the legal issues between the private parties. Now, let's discuss the key characteristics of the private laws. Let's discuss who are the parties involved. Private law primarily involves individuals or private entities, such as businesses, corporations, or organizations. The government is not a direct party, though it may play a role in enforcing legal agreements and judgment. Personal and commercial interest. Private law is concerned with resolving disputes and protecting the personal interests of the individuals or commercial entities. This includes enforcing rights, obligations, and duties between the parties. Voluntary relations. Private law often deals with the agreement or relationships that are voluntarily entered into by the parties. For example, contracts, property ownership, and the family matters. Now, let's discuss the resolution of the disputes. The primary function of the private law is to provide the mechanism for the resolving the disputes that arise between the private parties, often by the compensating the injured party for harm or enforcing an agreement. Classification of law as civil law and criminal law, and the classification of law can be done as civil law and criminal law. Civil law refers to the legal areas that deals with the action that cause harm to an individual or a private party like a company. Examples of the civil law cases includes instances of the defamation, breaking contract, negligence that result in harm or death and causing damage to the property. In civil law cases, individuals called plaintiff start the legal process by filing the suits. Typically, a judge makes the decision. Penalties in the civil law cases usually involve monetary compensation and never imprisonment. The plaintiff needs to prove the defendant's responsibility based on the preponderance of the evidence, which means showing it's more likely than not. Defendants in the civil cases don't have the same legal protection as those accused of the crimes. Civil law deals with the dispute between the individuals, organization, or entities where the rights and duties of the parties are in question. It is primarily concerned with compensating individuals for the harm or loss they have suffered due to the actions or negligence of others. Now, let's discuss the key characteristics of the civil law. Now, let's discuss the parties involved. The parties involved are usually private individuals, organizations, or entities. One party is plaintiff, the party bringing the case, and other is the defendant, the party being accused or sued. Objective. The main goal of civil law is to resolve the disputes, enforce the rights, and provide compensation to the injured party, rather than punish the wrongdoers. Let's discuss upon whom the burden of proof is there. In civil cases, the burden of proof is usually preponderance of the evidence. That is, the more likely than not the defendant is liable. Remedies. The typical remedy in the civil law is the financial compensation, damages, but it may also include specific performance, forcing the party to carry out a promise, or injunctions, order to stop or do something. Now let's discuss some examples of the civil law areas. Contract law deals with the agreement between the individuals or the businesses and ensure that the promises made are legally enforceable. Example, breach of contract case. Tort law governs the civil wrongs that causes harms or injury to another party. Example, personal injuries, claims, car accidents, medical malpractices. Property law involves disputes regarding ownership or use of the property. Examples, disputes over the land ownership or tenant rights. Family law addresses the issues related to the marriage, divorce, child custody, and other familial matters. Examples, divorce proceedings, child support disputes. Inheritance law deals with the distribution of a deceased person's estate either according to a will or according to the intestacy's law. Examples, disputes over the distribution of a will. Criminal law involves the actions that are considered crime against the public, society, or the state, even if an individual is the immediate victim. Example includes murder, assault, theft, and driving under the influence. In criminal law, the focus is on the protecting the public interest. This includes punishing and rehabilitating offenders while safeguarding the society. The government assigns the police and the prosecutors to enforce the criminal law. Public funds cover these services. If you are a crime victim, you report to the police who investigate and find suspects. Generally, if there is a proper charge with the evidence, the government, not the person who reported the incident, bring the cases to the court. Criminal law addresses the actions that are offenses against the society, the state, or the public order. It deals with the prosecution of the individuals or entities accused of committing crimes. The government, through the state, prosecutes the accused in the criminal cases, aiming to punishing the wrongdoer and deter criminal behavior. Now, let's discuss the key characteristics of the criminal law. Who are parties involved? In criminal law, the state or the government, through the prosecution, is the party bringing the case, while the accused person or entity is the defendant. The objective, the goal of the criminal law is to punish the offender and deter the crime. It seeks to maintain a public order and safety by holding individuals accountable for unlawful action. Burden of proof. The burden of proof in criminal law is beyond a reasonable doubt, meaning the prosecution must prove the defendant's guilt to such a degree that there is no reasonable doubt in the mind of a reasonable person. Remedies or penalties involved. The penalties in the criminal law includes imprisonment, fine, community service, probation, or in some cases the death penalty. The aims to punish the wrongdoer and the rehabilitate or deter the future criminal conduct. Examples of the criminal law offences are felonies, serious crimes such as murder, robbery, sexual assault, drug trafficking, usually punishable by imprisonment for over years. Misdemeanor, less serious offences like petty theft, minor assaults, or public intoxication, usually punishable by less than a year in a jail or a fine. White collar crimes, non-violent crimes typically committed by the businesses, professionals such as fraud, embezzlements, or insider trading. Public order crimes, offences that disturbs the public peace such as disorderly conduct, vandalism, or driving under the influence, which we also call DUI. Classification of law as a substantive law and the procedural law. The classification of law can be done as a substantive law and procedural law. Substantive law is the set of the laws that outlines the original rights and responsibilities of the individual. It can come from the common law, statutes, or a constitution. For instance, a legal claim related to the breach of contract, negligence, or fraud is considered as a substantive right under the common law. This law essentially defines the rule that determines the rights and the duties of both individuals and the groups. Procedural law. Procedural law is a set of the legal rules that establish how substantive law is developed, upheld, and used, especially within a courtroom. Procedural law deals with the specific processes that guide in progression of the case. It outlines the methods through which substantive laws are enforced and applied. In a sense, procedural law lay down the guidelines for ensuring the substantive laws are followed correctly. In concluding remarks, law can be classified in numerous ways based on their subject matter, the parties involved, the goal they aim to achieve, and the jurisdiction they apply to. Some of the major classifications are public versus private law, civil law versus criminal law, substantive law versus procedural law, and national versus international law. The system of classification help organize and understand the vast and diverse nature of the legal rules governing the society. The classification of laws as a systematic categorization based on its attributes holds immense significance in the realm of the legal comprehension. By providing a structured framework, it aids in navigating the intricate mass of the legal principles and the regulations. This organization not only enhances our understanding of the multifaceted legal landscape but also streamlines the legal education, research, and practice. Whether distinguishing public from the private law, substantive from the procedural law, or national from the international law, this classification fosters clarity and coherence, contributing to a more accessible, informed, and effective legal system overall. In conclusion, the classification of the law provides a structured way to understand the diverse and complex nature of the legal system and the various rules that governs human behavior. By categorizing law into the different branches such as public law and private law, civil law and criminal law, and substantive and procedural law, we can better navigate the specific functions, objectives, and relationships of each areas of the law addresses. Public law regulates the relationship between the individuals and the state, ensuring the public order and the protecting societal interest, while private law deals with the dispute between the private individual or organization, focusing on compensating or resolving personal conflicts. Civil law primarily deals with the individual rights and duties, providing remedies for the personal harm or breach of contract, whereas criminal law focuses on offences against the state and the society, aiming to punish the wrongdoer and deter the crime. Substantive law defines the rights and obligations of the individual, while procedural law dictates how the legal cases are conducted and enforced. The national versus international law, the common law versus civil law classifications highlight the diversity in the legal system around the world, with some nations relying on written codes and other following judicial precedents. Moreover, specialized branches like commercial law, environment law, family law focuses on specific areas of society addressing a particular issue with the tailored regulations. Ultimately, the classification of law not only helps in organizing the legal language but also ensure that the legal system remains comprehensive, adaptable, and fair. It enables a more efficient application of the law to resolve the dispute, uphold the justice, and maintain the order in the society. I hope this lecture has enriched your knowledge of the legal classifications. Keep exploring the law as it is the cornerstone of a just and orderly society. Thanks for watching this program.